my lawyer is overcharging me? I'm going to answer this question with a series of questions. For those of you who have my free handout, a dozen questions to ask before you hire your attorney, some of these should sound familiar. And remember, these are generalizations. First, you should have a copy of your fee agreement or engagement letter, as well as a sheet setting forth the billable rates of every attorney, paralegal, and staff member who is expected to work on your file. So if you're concerned about being overcharged, the first thing to check is whether everything lines up. Are you being billed for additional costs and expenses that were never referenced in the engagement letter or verbally discussed in advance with the lawyer? Is there a new attorney with a billable rate that's $200 an hour more than anyone else's, regularly being consulted with, and you have no idea why? At minimum, you have the right to an explanation, and your lawyer will be on notice to do a better job of communicating potential additional costs with you going forward. If you're not under a flat fee arrangement, you can and should expect to receive an itemized billing statement from your lawyer. Some institutional clients don't want this, but most smaller companies and individuals really do. So requesting an itemized bill if your firm doesn't provide it automatically will not be a surprising request. Different lawyers provide varying levels of detail on their bills, but if you read each line item carefully, you'll have a gut feeling if anything seems ridiculous or overcharged. This isn't necessarily malicious. We try to be meticulous about this, but mistakes can happen. A decimal point can drop off, so 0.5 hours accidentally becomes 5 full hours. Or work from another matter might get improperly posted on yours. Again, this is rare, but if you see something that is off, you absolutely can and should ask your lawyer about it before you pay your bill. Are you tracking to remain within the general range of expected costs that your lawyer estimated at the start of the engagement? If not, has the scope of work expanded, or is there another reason why? If you need a lot of extra hand-holding, or if you request multiple revisions to a document, or you change your mind about an approach, or if you've elected to add on services after the fact, you should be prepared that your bill is going to trend toward the higher end of the estimated range, or even exceed it. One way to mitigate the risk of an unpleasant surprise at the end of the month is to discuss a number at which point the lawyer will stop work and reconnect with you about how to proceed. So, if your fee estimate is between $3,000 and $5,500, and let's say $5,500 to $6,000 is really the true cap of what you can spend right now, you can ask your lawyer to advise you when you hit $4,500 in legal fees, and then figure out how to best spend that remaining $1,500 or so, and reevaluate your budget and strategy more generally. Now, please understand, if you're calling us 3 days a week for 45 minutes a pop, we are going to assume that you understand you're being charged for that time, even if no written deliverables have been produced yet. And believe me, those phone calls can add up quickly. I hope you take some comfort in the fact that padding hours, that is, inflating time spent on work or just outright making things up, is actually far less common than I think most people assume, especially with smaller firms and smaller clients. If you can't bring yourself to believe that for most lawyers, ethics outweighs greed, then consider that lawyers are extremely risk averse and they don't want a client to bust them for lying about the time they spent. They also don't want to spend time arguing and renegotiating a bill when that time could be spent doing billable work. And they don't want to damage their long-term relationships with a client for a marginal gain in a single month of fees. For every lawyer that pads his bills, there's another lawyer that actually writes off good time to keep the client happy and on budget. It's worth noting the flip side of this, though. If you receive a bill from a lawyer who actually cuts her billable hours for your benefit, and then you come back asking for a courtesy discount or complaining about why the bill is so high anyway, that lawyer is probably going to have a lower tolerance for negotiating the bill down further, since they'll feel like they've already been so favorable to you with what they've charged. It's the folks who've had their hours that are going to be willing to spend time negotiating your bill or doing you favors, since they're coming out ahead regardless. That's just some food for thought. I'll conclude with this. As a rule, most lawyers really do try to bill fairly, if not generously to you. We do not want your bill to contain any errors, and we will fix them immediately when they're discovered. If you're distressed that, say, your project seems to be the training grounds for an inefficient junior associate, you're justified in being frustrated, and a good lawyer will remove that inefficient lawyer from your transaction, or more likely keep her on but write up all the time before you ever see it. And with that said, as a rule, we do expect clients to pay their bills in full and on time. And most engagement letters reserve the right to terminate legal services if you refuse to pay or to get current on your debts. Please do not be one of those clients that tries to renegotiate every single bill every single month. Even for clients that we otherwise like and respect, this is a spectacular annoyance, and it's a terrible use of everyone's time. Depending on the attorney's patience, there's a chance that it'll result in you getting dropped or deprioritized as a client. Business owners, how do you budget for legal expenses?